looking at a showing agreement. Now, I'm a broker and an attorney here in Florida. My name is Leslie Quinn. And, pursuant to the recent litigation they've had in the course of the past year or two, the commissions, the way the commissions are now paid is that the buyer has to pay a realtor. For all intents and purposes, previously, the listing agent would be paid, and the listing agent would split their commissions with the buyer's broker. Now we require an agreement. National Association of Realtors as agreed to specific terms is requiring agents who work with buyers or potential buyers have to have an agreement in place. It could be a showing agreement like this one, or it could be a buyer's broker commission agreement or some sort of a commission agreement. Okay. It has to be in writing with the potential buyer. Okay. In this case, we have two parties, which is the consumer, who was in effect the potential buyer, and the broker, meaning the buyer's broker, the individual, the agent that is going to show the property to the potential buyer. Okay. But in this case, we're referring to consumer and broker. Okay. Now, this is to show property, and we have to designate the properties that are being shown. It might be one, it might be two, it might be three, it might be a number of them. You must list the properties in order for the compensation to be paid, right? And so we have here is that the consumer wants to tour, negotiate the purchase, negotiate an option, exchange, lease, or other acquisition of the property or properties listed below. They're using the services of you, the broker, or the buyer's agent, for this purpose. If the consumer, meaning the potential buyer, enters into a fully executed contract for sale, purchase, or a contract to lease, or a lease option, etc., that they will be entitled to compensation. The buyer's broker's obligations are to assist them in showing and negotiating on the transaction, right? They're going to assist in any closing that might result from the transaction and cooperate with the other real estate licensees that are working with the owner to complete the transaction. Now, the broker may work with other prospective buyers who want the same property. Have to disclose it to the individual working with the consumer is that, basically the broker may in fact show the property to other potential buyers. Okay. There is a duty not to disclose any information with regard to that, any material terms and conditions and so forth. Now, they must also, here comply with fair housing. Okay. We're always bound by federal law, but also have a disclaimer in here saying that you're not responsible for any third parties, right? Anybody who, the services that are being provided by the buyer's broker. It's very important that the consumer understands this provision here, and you should have similar provisions in your agreement. But the consumer agrees to cooperate with the buyer's broker in accomplishing the objectives, meaning contact that agent deciding to negotiate for the acquisition of one or more of the above listed properties. That happens frequently where the buyer will turn around and they'll view a property with one agent and then they will come back to the property with another agent. If in fact you have this agreement in place that will protect you because the consumer is obligated to use you if you actually show them that property. Okay. Must also inform other real estate licensees they have already worked with you on this property or these properties. so that the other agent is well apprised that that you were the procuring cause basically of and you started the process of this potential negotiation on this property. You should be involved in that going forward. Now, providing the broker necessary third parties with accurate information. Okay, with regard to their ability to acquire the property, if you're not haven't been pre-approved for a loan and you can never qualify for that loan, don't waste the agent's time, right? So we have to make sure that they comply with that. With regard to a credit check, normally that's not done by the real estate agent or their brokerage unless they're doing property management and they are looking to lease the property. It might be a circumstance, but for all intents and purposes, it's not something that normally we do, is run credit checks. Identify and hold broker harmless from losses, damages, and costs, expenses of any nature because of the consumer's misrepresentations or default on any agreement. Now they might go through and default on and not purchase the contract. They might default on the purchase and sale agreement. In that case, the brokerage is still entitled to damages. So, you have to keep in mind that the consumer must understand this. They also must make a diligent good faith effort to perform under any purchase and sale agreement. Now, we always use the diligent good faith effort. It's always determined by fact and circumstance and court of law if necessary, but they have to again, it has to be something done in good faith. They have to intend to actually purchase these, not just, and to go through with the purchase if there is a contract. Okay. Now, compensation. Broker's compensation is earned during the term of this agreement or any renewal of it. Okay. So, it's deemed earned when the broker's services are provided. Okay. You must understand that, compensation will be determined pursuant to the terms of compensation. Now, in your state, you might have certainly have a similar agreement. If you're drafting or if you're having legal counsel draft agreement for you, it should have pretty much similar terms there. The compensation to a buyer's broker must be specific. Okay, so when we look at this, we will have a purchase or exchange at dollar amount or percentage, right? Total purchase price, or a dollar amount or a percentage plus a certain, maybe a transaction fee and so forth. Will no later than the closing on the contract. Okay. However, closing is not a prerequisite for broker's fee. Again, if they default and they're not acting in good faith and they make misrepresentations and so forth, your fee or the broker's fee is still due. Okay. Lease, again, if we're leasing, it would be a dollar amount of percentage for month's rent. All of these are negotiated between the consumer and the broker. Okay. If they're going to do a lease purchase agreement or maybe a lease with option to purchase, normally they lease it for a period of time and then they exercise their option to purchase. If you're using standard contracts, like our standard contract in Florida, it's an installment agreement. It really is. You have to be very careful because that said is that with an installment agreement, the fee for the sale is due. Pretty much, court looks at it and they say, well, it's a contract for purchase. It's an installment agreement. Fee is due up front. Now, a true lease and option. The lease does not reference any option to purchase. Option will certainly reference the lease. That there's a lease in place and that the lease has to be current. The option doesn't get exercised until it gets exercised prior to the lease ending, intents and purposes, but two separate agreements. And so, when we look at that, we're saying, okay, well, we're going to be paid for the lease and getting you purchase. And then when you do purchase, any fees that are due for the sale are going to be paid to the broker at that time. And we're going to credit any any brokerage fees paid for the lease up front, credit them against any compensation due at the back end, meaning for the sale. Okay. So just what this, entitles you to is that further compensation when the sale does close, but it's offset by whatever amounts are paid by these, unless you've modified it to say that, these fees are not going to credit that amount. Okay, so you can do that. Up to you. Okay. But you have to understand that in a true lease option situation, there's a lease and then there's an option to purchase. You have to be very careful, and you should seek legal counsel when you're doing any kind of lease purchase agreement, because not only does it affect you legally from the perspective of, if you have a landlord or, a seller that, believes that he's, leasing the property, but he's making credits and so forth of the rent, and he's, allowing the tenant to make improvements to the property. Then what happens is it's really, truly, and honestly an installment contract. And so, those are highly litigated. Be very careful. But when we come to 6, we have a retainer. Now, pursuant to the compensation arrangements now, is that the broker and the consumer are able to negotiate a retainer, meaning just like an attorney or other professional, is that you get a retainer up front, earned and payable. I know here they have it as earned and payable upon execution of the. A retainer is in addition to any compensation earned by the broker, meaning the broker, if they're paid for their real estate services through, you have an agent that is the listing agent, and you have entered a showing agreement with the buyer, is that their compensation is coming from as a listing agent, is coming from the seller, and that compensation will not be affected by any compensation given by the buyer to the broker. Okay, so the retainer is in addition to any compensation earned. Retainer is for real estate services as described, and does not constitute a fee paid for rental information or rental list and so forth. Okay, that's specific to Florida, but in essence, a retainer is used lots of times it's used to, in this circumstance, to ensure that the buyer is really, truly, and honestly a buyer, right? The consumer is in faith. They want you to, they want to take up the broker's time in seeing these properties. So therefore they're going to pay for the services of that broker, right? Now, when you look at a retainer fee, though, it can be structured in many ways. A retainer is used against the services that are provided. So you might take, a $2,000 retainer, and, for every time you perform services for them, it's a $300 fee. So then you're taking that $300 and you're applying it towards the, showing the property to them. Okay, so keep in mind that that's how normal retainers work, is that it's used to pay for services that are going to be provided. Now, this retainer must go to the broker and not to the agent. To understand that also, so be very careful with that. Dispute resolution. Pursuant to Florida law, mediation is normally the cheapest and the quickest and most effective. But, again, the dispute resolution provisions always discuss that with between the parties. They misunderstand what that means, okay, and how that works. And with regard to modifications, we have the mandatory language is that brokerage commissions are not set by law and fully negotiable. Broker may not receive compensation from any source that exceeds the amount agreed to with the consumer. We must always have the language in every agreement now with regard to compensation is that the fees are not set by law and fully negotiable, whether it be with a seller or with a buyer. And we also have to understand that whatever the consumer has agreed to in this, if they say that they're only going to pay 2% of the sales, the price of the sales price, then it's 2%. That is the cap. Broker may receive separate compensation from the owner of the property. Again, that's if they're the listing agent, because it's for services rendered to the owner. The consumer is not responsible for those services. So we're separating out the services provided to the buyer and services provided to the seller. Okay. However, we're not talking about if you, the broker here, are not a listing agent, and you're working on behalf of the buyer, you can be paid from, if the seller or the seller's brokerage wants to pay the buyer's agent or the buyer's broker, they can, but all compensation cannot exceed the amount that the consumer has agreed to in this agreement. So be very careful. These agreements must be looked at in total with regard to the transaction, and they have to be modified to reflect what everyone has understood and agreed to. Okay. Consumer and the broker have to actually sign off on this. It's very important, that you have, again, the terms are clear, they're understandable, everybody's on the same page, there's a meeting of the minds, and that, you have, in fact, included all the properties that you're taking care of, and you're showing them. Now, you can add them. When you add the properties to it, make sure the consumer or the potential buyer actually initials that. You cannot, just add it unilaterally without having them actually sign off on it. So at that point in time, if you're starting to show them multiple properties, you probably want to go to a buyer broker agreement, because then it would cover all the properties. And you wouldn't have to, go back and initial and date any changes to an agreement. Both parties must do that if the agreement is changed. So to avoid any disputes, be sure to use this agreement, and then proceed to move on to a buyer broker agreement if in fact you have more than a few properties that you're showing them. If you have any questions or concerns, please let me know. We're always we have our brokerage firm, we have our consulting company, and we are, able to consult with you, teach you more about real estate contracts and how they work, and also, assist you with any deal structures and any issues that you might have questions on. So be sure to take a look at our trainings and our programs that we offer. But be very careful. Again, showing agreement. You will have one similar across the board in your state. Just be careful. Be sure to understand the terms that are in that. And then if you draw up your own, make sure you have legal counsel actually review it to ensure that you are complying with the law and that you understand your obligations either as a consumer or as a broker. Okay. Take care. Bye.